Let's kick things off today with a question that sounds simple on the surface, but the answer really tells the story of a nation. Where do a country's laws actually come from?
It's never just one big book or one single person. The real answer is, well, it's a lot more like a complex structure, with all these layers of history, authority, and tradition all working together.
It's not just a document, it's an entire system.
And in Kenya, the best way to visualize that system is as a pyramid of power. So, over the next few minutes, we're going to break this whole pyramid down piece by piece, starting right at the very top.
Right at the apex, the absolute peak of our pyramid, is the single most powerful source of law in Kenya, and that is the Constitution. Everything else sits below it and has to answer to it.
And this isn't just a friendly suggestion. It's the master blueprint for the entire country. It sets the rules of the game for literally everyone, from the highest levels of government right down to every citizen. Its authority is absolute.
The Constitution doesn't just imply its power, it spells it out loud and clear. This quote from Article 2 is basically the legal knockout punch. Any law that dares to contradict the Constitution is just void, gone. It is that clear-cut. So, when you get right down to it, the Constitution is juggling three massive jobs all at once. First, it creates the government. Second, it limits that government's power. And third, and this is absolutely crucial, it protects the fundamental rights of every single citizen.
Okay, let's move one layer down the pyramid. Here, we find the laws that are created directly by the people's elected representatives. We're now in the world of the legislator, which you probably know as parliament.
Now, this is what most of us think of when we hear the word law, right? It's a formal, written rule that's been passed by Parliament. And in Kenya, that means both the National Assembly and the Senate are working together to create these statutes, which govern pretty much everything, from traffic rules to international trade. But an idea doesn't just magically become a law overnight. Oh no, it goes on a pretty tough journey. A proposed law, or a bill, is first published so the public can see it. Then it's debated in Parliament, pulled apart and examined by committees, and eventually voted on. And only after it's passed all those stages and gets the president's signature does it finally become the law of the land.
Now look, Parliament can't possibly write every single tiny rule for every situation. So what they do is, an act will often give a government minister or some other official body the power to fill in the details. Think of it like this. Parliament passes a law saying all cars must be safe, and then a minister writes the specific, detailed regulations about brake standards and tire pressure. That's the fine print.
All right. The next layer of our pyramid is a fascinating dive into legal history. Because of its colonial past, a huge chunk of Kenya's legal DNA comes directly from England.
This is a kind of law that wasn't written down in some big book by a parliament. Instead, it was built up slowly, case by case, decision by decision, by judges back in England. It's this organic system that's based on tradition and precedent, and it forms a major part of Kenya's legal foundation today.
But the common law was far from perfect. It could be incredibly rigid. I mean, if you filled out the wrong form, even by a little bit, your whole case could be thrown out. Justice was often painfully slow, and the only solution a court could usually offer was money, even when what you really needed was for someone to, say, stop dumping trash on your property.
So the harshness of the common law obviously created a big problem. It needed a fix. And that fix was a kind of parallel system designed to deliver fairness when the strict letter of the law was failing. It's called equity.
Equity basically acted as the court of conscience. Where the common law was rigid and stuck in its ways, equity was flexible. It introduced new solutions, like injunctions, which are court orders telling someone to stop doing something. The whole point was to achieve a just and fair result, not just blindly follow old procedures.
So let's move down to the base of our pyramid. This is where the law stops being just text on a page and becomes a living, breathing thing, shaped every single day in courtrooms and communities all across Kenya.
And this is where we really see that legacy of the common law in action. When a judge makes a decision, it's not just about that one case. The legal reasoning they use sets a precedent. It becomes a rule that lower courts have to follow in similar cases down the road. So in a way, judges are constantly interpreting, clarifying, and even shaping the law.
Now, to understand case law, you have to know this. Not everything a judge says is legally binding. Think of it like a math problem. The ratio decidendi is the final answer and the formula you use to get there. That's the core legal reasoning that other courts have to follow. Then you have the obiter dicta. Those are like the notes in the margin, the judge's other thoughts. They're persuasive, sure, but they're not the binding rule itself.
And finally, we reach the very foundation of the pyramid, where the law acknowledges that Kenya is a nation of incredibly diverse communities. So alongside all the formal court decisions, you have African customary law, which governs personal things like marriage and inheritance for many ethnic groups, drawing on centuries of tradition. And in the same way, Islamic law provides a framework for Muslims on similar personal matters. These aren't just footnotes, they are living legal systems and the bedrock of justice for millions of Kenyans.
And there we have it, the pyramid, complete. You've got the absolute power of the Constitution at the top, then the laws made by Parliament layered with the deep historical influence of English common law and equity, and the whole thing is built on this foundation of case law and the customs of the people.
So you see, this complex pyramid isn't just some dusty legal framework, it's a portrait of Kenya itself. It's a nation that's been built on history, empowered by its people, and is deeply rooted in diverse traditions. Which leaves us with one final thought. What does this unique blend of laws truly reveal about a nation's soul?
So your business is taking off, right? And you've probably hit that wall. You just can't be everywhere at once. You need people on the ground, closing deals, buying supplies, basically being you. But, and this is the big question, how do you make that legit? How do you legally create another you? Yeah, let's really get into this. Because we're not just talking about hiring an employee, we're talking about giving someone the power to legally bind you, to sign contracts in your name, to spend your money. So how on earth does the law make it possible for you to, well, clone yourself for business? Well, the legal world has a pretty cool answer for this, and it's called agency. Think of it as the official framework that lets someone, the agent, literally step into your shoes. You're the principal, and they get to act with your authority. It's basically the law's permission slip for them to be your business twin. There's this old Latin saying that's pretty much the golden rule here. It boils down to this. He who acts through another acts himself. What that means is, when your agent does something they're authorized to do, in the eyes of the law, you did it. Their signature? It's your signature. Their deal? It's your deal. And that right there is what makes this whole thing so incredibly powerful and, yeah, pretty risky too. Okay, so how does this whole agent thing even start? You're probably thinking it's all about signing some long, complicated contract, right? Well, not always. An agency relationship can actually pop into existence in a bunch of different ways, and believe it or not, sometimes completely by accident. So we're going to break down the 5 main ways this happens. You've got your straightforward agreement, then there's something called ratification. That's when you approve a deal after it's already done. We'll also look at Estoppel, the accidental agent, which is fascinating, plus necessity for emergencies, and even how it can come up in family situations. All right, the most common way is just a simple express agreement. You literally just say, hey, can you sell my car for me? That's it. It can be totally verbal. But, and this is a huge deal, especially under Kenyan law, if your agent needs to sign a formal deed, like for selling a piece of land, that verbal agreement is not going to cut it. You have to use a special document called a power of attorney. If you mess that up, the whole deal can just, poof, be invalid. Okay, but what if someone goes and makes a deal for you without your permission? Well, there's this thing called ratification that lets you basically say, okay, I'll take it. But the rules are super strict. For starters, you had to exist when the deal was made. The person had to be clear they were acting for a boss, not for themselves. You need to know all the key facts. And here's the kicker. You can't just pick the good parts of the deal. It's all or nothing. You have to take the whole thing, warts and all. Now, this next one is where it gets really, really interesting. You can actually create an agent by accident, not by what you say, but by what you do. It's called agency by estoppel, or sometimes holding out. Basically, the law says if you make it look like someone's your agent, you can't just turn around later and say just kidding if someone else believed you. So how does this accidental agency happen? It's kind of like a 3-part recipe. First, you have to make some kind of representation. You, the principal, do something that makes it look like this person works for you. Maybe you let them use your company's letterhead. Second, someone else, a third party, has to see that and believe it. And third, they have to act on that belief, like giving that person goods on credit. If all 3 of those things happen, boom, you're on the hook. There's a famous old case that just nails this point. Picture this. A pub owner hires a manager and puts the manager's name right up over the door. But privately, he tells him, don't you dare buy cigars on credit. Well, what does the manager do? He buys cigars on credit. The court said, tough luck, owner. Putting that name over the door was a public sign that this guy had the usual powers of a manager, and buying supplies is one of those powers. That secret, private instruction, it meant nothing to the outside world. All right, it's also super important to know that not all agents are the same, not by a long shot. Knowing what type of agent you're working with is key because it totally changes their power and your level of risk. In the world of business, the two big ones you'll hear about are factors and brokers. And the difference between these two is absolutely crucial. A factor is someone you give your actual stuff to. You give them possession of your goods to sell. So to the outside world, they kind of look like the owner. A broker, on the other hand, is just a middleman, a negotiator. They never even touch your product. They just connect buyers and sellers. This one difference, possession, has massive legal consequences. So let's just hammer this home. If you only remember one thing from this part, make it this. A factor holds your goods. A broker is just a negotiator. That's it. That physical possession is what changes everything about their authority and how they can legally bind you to a deal. Okay, so we know who the players are. Now let's talk about the rules of the game. It really all boils down to two main things. What an agent is allowed to do, that's their authority, and what they absolutely have to do for you, that's their ditty. So an agent's power really comes in two flavors. First, there's actual authority. That's what you and the agent have actually agreed on, whether you said it out loud or it was just implied. But then there's apparent authority, and this is the danger zone. This is the power a third party thinks your agent has, all because of something you did. For example, maybe you told your agent, hey, don't spend more than $1,000. But if you've let them sign $5,000 deals in the past and you paid for them, well, you've just created the apparent authority for them to do it again. Now, in exchange for all this power, your agent owes you one thing above all else: absolute loyalty. This is what's known as a fiduciary duty. It means they must follow your lawful instructions. They have to avoid any conflicts of interest. They can never, ever take a secret profit or a bribe. They have to use proper skill and care, account for every single cent, and keep your confidential info safe. This isn't a list of suggestions. It's the absolute core of the entire relationship. And that duty to do the job themselves is summed up in another one of those classic Latin legal phrases. Don't worry, the idea behind it is super simple, but it's something every business owner needs to get. It simply means a delegate cannot delegate. Think about it. You hired that specific person for a reason, right? Because you trust their skills, their judgment. They can't just turn around and pass the work off to some random subcontractor unless you say it's okay. They were hired to do the job personally. But what happens when it's all over? You know, the job is done, or maybe things just didn't work out. These relationships don't last forever. They can end because you both agree, or one person decides to end it. Or sometimes they end suddenly and automatically, thanks to a rule of law. And honestly, this might be one of the scariest parts of agency law. Certain events will kill the agency relationship on the spot. Instantly. No notice required. If the principal dies or goes bankrupt, poof, the agent's authority is just gone, vanished in a split second. And there's a case that shows just how brutal this rule can be. A lawyer was working on a case for his client. The thing is, unknown to him, his client had become mentally incapacitated. The law is crystal clear. The second that happened, the lawyer's authority was terminated. He kept working, thinking he was representing his client, but he was actually acting without any authority at all. And in the end, he was held personally responsible for all the legal costs. It's a harsh lesson for sure. So that really makes you think, doesn't it? If you're an agent, how do you protect yourself from something like that? Your entire authority to act can just vanish, and you might be the last to know. It just goes to show you the huge amount of trust and risk that's built into this whole thing. Okay, so let's wrap this up with a quick checklist. 3 key things you absolutely have to remember. Number 1, your actions can speak way louder than a contract. You can create an agent by estoppel without meaning to. Number 2, always know the difference between the real authority you gave your agent and the apparent authority outsiders think they have. And number 3, an agent's duty is to you and you alone. That loyalty is non-negotiable. At the end of the day, an agent isn't just an employee. They're your legal twin. They have the power to make you a fortune or to completely ruin you. The law of agency gives you this incredible tool to grow your business, to be in 100 places at once, but it all comes down to one single massive question. Who are you really willing to trust with your name?